Producers continue reviewing the U.S. Supreme Court opinion involving DACA, and it has some huge ramifications for agriculture in terms of how administrative agencies can regulate farming and ranching activities. Roger McEowen with the Washburn University School of Law joins us now for a further look in today's Rural Money segment. Roger, thanks for joining us. Let's start with some background on the matter.
Good to be with you, Christina. Yes, this is the DACA opinion that came in late in the Supreme Court's term in June. And what they did, of course, is deny the ability of the Trump administration to just administratively repeal the program that had been created administratively without going through the Administrative Procedures Act back in 2012. And the Supreme Court, in a split decision, said that they could not. They had to give greater reasons for revoking the program and go through more procedural hoops to get it done, even though the prior administration had not done so to create it.
You know, you mentioned that Administrative Procedures Act. Can you expand on that and bring us up to speed on what exactly that does?
Well, it was created back in 1946, and basically it's the Constitution for administrative law in the United States, and it governs how federal administrative agencies are to go about developing regulations and gives the federal courts oversight authority over all agency actions. Basically, what it does is it requires a federal administrative agency, when they enact rules that will be applied with the force of law on citizens, to go through the administrative procedures rules, publish those rules for notice and comment so that the public can see them and comment on them before they become finalized and then implemented.
So how does this apply to agriculture? What's the big takeaway for our farmers and ranchers here, Roger?
Well, this opinion applies in a very important way to agriculture. Justice Thomas, for example, the most senior judge on the Supreme Court, authored a rather biting dissent, and basically his point was, look, this was unlawful from the beginning. It was not promulgated through the proper procedural channels, and it is certainly appropriate for a subsequent administration to revoke it without going through the procedural channels. And requiring the agency to go through hoops, as he said, would hamstring agencies from repealing illegal conduct by prior agency agency action coming from prior administrations. Now, the application to agriculture is huge because farmers and ranchers often deal with rules developed by federal and state administrative agencies, and those rules often involve substantive rights, and so they are subject to the notice and comment requirements of the APA. And so if the government doesn't have to follow those rules, then farmers and ranchers will be surprised when those rules get enforced against them with the force of law, wondering, where did that come from? Why did I not see this? Why didn't I have an opportunity to comment on this before it became enforceable against me? And the USDA has had a long history of being rather poor at complying with the APA. And we've seen this in a number of areas, particularly with respect to swamp buster and wetland issues. And the problem has always been there with the IRS. IRS changed the CRP self-employment tax rules unilaterally a number of years ago without going through procedural hoops. They got pushed back by the U.S. Court of Appeals by the Eighth Circuit. But this is a power grab that is allowed by the Supreme Court for federal administrative agencies, and farmers and ranchers need to be aware of how that opinion can apply to them. And I fear what's going to happen in the future once the agencies realize that they've got this power.
Oh, you always do such a good job of forewarning us about what to look for down the pike. You can find out more, washburnlaw.edu/WALTR, if you'd like to read more of Roger McEowen's in-depth thoughts, and he always does a good job of laying it all out for us in perfect detail. Thank you, Roger McEowen with the Washburn University School of Law.